Dear Chief Acosta, I intend to apply for the registration of the land I have been occupying for 32 years now. Jose told me to ascertain whether the land was alienable from the inception of my occupation, otherwise my application would be denied. Is Jose correct? In the first place, is it important to determine if a land is alienable? Herald.
Dear Herald, only lands classified as alienable and disposable land of the public domain may be covered by land registration. This is in consonance with Section 14 of Presidential Decree Number 1529 or the Property Registration Decree, which states that
the following persons may file in proper court of first instance an application for registration of title to land, whether personally or through their duly authorized representatives. 1. Those who by themselves or through their predecessors in interest have been in open, continuous, exclusive, and notorious possession and occupation of alienable and disposable lands of the public domain under a bona fide claim of ownership since June 12 of 1945 or earlier. 2. Those who have acquired ownership of private lands by prescription under the provision of existing laws. 3. Those who have acquired ownership of private lands or abandoned river beds by right of accession or accretion under the existing laws. 4. Those who have acquired ownership of land in any other manner provided for by law.
the provisions of the law for land registration were fully explained in the case of Republic of the Philippines versus Philippine National Police, where the Supreme Court, speaking through Honorable Associate Justice Ramon Paul Hernando, stated that
For registration under Section 14(1), to prosper, the applicant for original registration of title to land must establish the following. 1. That the subject land forms part of the disposable and alienable lands of the public domain. 2. That the applicants by themselves and their predecessors in interest have been in open, continuous, exclusive, and notorious possession and occupation thereof. And 3. That the possession is under a bona fide claim of ownership since June 12 of 1945 or earlier. On the other hand, registration under Section 14(2) requires the applicant to establish the following requisites. A. The land is an alienable and disposable and patrimonial property of the public domain. B. The applicant and its predecessors in interest have been in possession of the land for at least 10 years, in good faith, and with just title, or for at least 30 years, regardless of good faith or just title. And C. The land had already been converted to or declared as patrimonial property of the state at the beginning of the said 10-year or 30-year period of possession. From their respective requisites, it is clear that the basis for registration under these two provisions of law differ from one another. Registration under Section 14(1) is based on possession, whereas registration under Section 14(2) is based on prescription. Thus, under Section 14(1), it is not necessary for the land applied for to be alienable and disposable at the beginning of the possession on or before June 12, 1945. Section 14(1) only requires that the property sought to be registered is alienable and disposable at the time of the filing of the application for registration. However, in Section 14(2), the alienable and disposable character of the land, as well as its declaration of patrimonial property of the state, must exist at the beginning of the relevant period of possession.
applying the law and jurisprudence in your situation, the land you are occupying must be classified as alienable and disposable as it is the only type of land that is allowed to be registered under the Property Registration Decree. Considering that your basis for registering the subject land is your occupation thereof for 32 years, which would mean that it began later than June 12, 1945, then Section 14, Paragraph 2 of the Property Registration Decree applies to your case, or registration based on prescription. This requires the subject property be classified as alienable and disposable land and declared by the state as patrimonial property or no longer intended for public use or for public service from the start of the relevant period of your possession. We hope that we were able to answer your queries. Please be reminded that this advice is based solely on the facts you have narrated and our appreciation of the same. Our opinion may vary when other facts are changed or elaborated. Tomorrow, we'll look into another question from our viewers and readers of Dear PAO. This is your host, the Chief Public Attorney of the Republic of the Philippines. At your service, Presida V. Rueda Acosta. Goodbye for now.